State of Florida versus Michael Morrison. We start by having counsel make their appearances on the record.
John Reed for the state.
Michael Gross on behalf of Mr. Michael John Morrison.
Michael Cook, also on behalf of Mr. Morrison.
Okay.
And I'm Michael Morrison. You recognize me?
Yes. I know that Mr. Morrison has joined us here in open court. Good morning, everyone.
Good morning.
Welcome. Okay, we are here for some hearings in this case. I did have an opportunity to review, I think, the matters scheduled for hearing today before coming out, including, I got a memorandum of law from the state, some citations, and motions on both sides. So I had a chance to review those. Are we anticipating this as an evidentiary hearing, I assume?
Yes, Your Honor, we are. And that's what had been scheduled for today.
Okay. Both sides ready to go?
Yes, sir.
Okay.
Defense is ready, Your Honor.
All right, very good. Thank you. I don't know what you prepared for today, but it would be of some benefit to me to start with a very brief kind of overview of, not the case, I read the 707, I'm familiar with the case, but the issues for today. And I'm talking about a forest and trees kind of approach, real short, right to the point, just a couple minutes. That'd be...
Your Honor, I have no objection proceeding, since it's our motion to dismiss that started this. However, I'd like to invoke the rule of sequestration at this time.
Okay, I don't know who the witnesses are. Mr. Reed, do you have witnesses in court?
Yeah, did you want to swear them everybody in at once? Is that how
I'll
you do it?
swear them in as they
Okay.
come in and testify. But you do have
Yes, sir.
witnesses. Okay, Mr. Bross, you got any witnesses?
I
in court?
do, Your Honor.
Okay. All right, so your two witnesses are over here?
Yes, sir.
And Mr. Bross, your witnesses are?
Over here.
These two gentlemen over here.
Yes, Your Honor. That's
All right, folks, the parties have invoked the rule of sequestration. Let me tell you what that means as far as you're concerned. It imposes two limitations on you. First is that you're not allowed to discuss your testimony with any other witness. So you can't talk about the case and your testimony or the issues of the case with each other. And if you overhear somebody talking about the case in your presence, move. Okay? Just so you don't have to listen to that. You can't do that. You're not permitted to discuss your testimony with any other witness. You can, however, discuss your testimony with the lawyers. You're free to do that, but not any other witness or party to the proceeding. Okay? Second thing is that you're not to be present during the testimony of any other witness. Again, the whole idea here is that we're trying to preserve your testimony without being influenced by the testimony of any other witness or party. Okay? So what that means is once we start into the presentation of the case, you're going to have to remain out in the hallway until we call you up to testify. All right? Anything else you want me to tell the witnesses?
Yes, sir.
When you do come in, if you'll just walk up to the podium right here, we'll place you under oath, and then I'm going to ask that you take a seat in the witness box right over here so that you can give your testimony.
Your Honor, we have another witness that's going to be here at 11 o'clock. Is our expert, Mr. Bedard.
Okay?
And we'll instruct him accordingly.
Thank you. I assume as an expert witness, he's probably well acquainted with the rules of sequestration, but if you need me to say anything to him, just let me know.
I understand, Your Honor.
All right? All right, so we're ready to proceed?
We are, Your Honor.
All right, gentlemen, if you wouldn't mind waiting outside until you're called in to testify. Thank you.
She's in Sanford, but I don't know if she wants to be here. Anyway, we'll arrest her for making a false police report. I'll pass her, you can ask him about it. She made a false police report. That's it.
Whenever the court's ready, Your Honor.
Okay, I'm ready.
Thank you, Judge. Judge, again, good morning. Michael Gross on behalf of Mr. Michael John Morrison. As we indicated to the court, we filed a motion to dismiss. I know the court wants the brass knuckles. You want me to get right to it, and I'm going to try to very quickly, but bear with me. I just want to set a minor foundation, if I could, that as the court will recall, that the events occurred on or about October 21st, 2012, wherein it was alleged that Mr. Michael John Morrison was with an individual by the name of Leah Mays. She is a female, and it was alleged at that time that they were at a location heading to 331 North Timber Creek in Ormond Beach, and they were in or about that location, and the couple had paid for a food bill and headed home to that location, when in fact at some point they were getting ready to grill steaks and do things. Mr. Morrison changed his mind and said, you know, I'm going to take you home to your house, your apartment, which was 408 South Ridgewood Avenue. It was apartment number 206 on his Harley Davidson. It was thereafter alleged that while en route there, he took her there and she didn't want to get off the motorcycle, and it's some information that the court's going to hear that she did finally get off the motorcycle. We believe she fell. She was injured. Irrespective, my client left her there at her place that she lives, and she gained entry into her apartment allegedly without keys. We have people to testify how she gained entry, where she went, and then thereafter my client, who's going to be alleged, left that location and went home to his residence, which again is at 805 South Flamingo Avenue, and that's where he was living at the time. And he went home eventually, and when he got home, it was then further stated that an individual, an officer with the police department, the Daytona Beach Police Department, Dale Kelly, was called to the scene of this incident of the alleged battery out there off of Ridgewood Avenue, and he talked to individuals who were there, made a police report, and further talked to Miss Mays, and it was then at that point that he left that area with Miss Mays and met up with a Officer Matt Armstrong, corporal with the Holly Hill Police Department at a Crystal's. Three of them met there so that the Holly Hill Police Department could be involved in going to the South Flamingo Avenue location and the location where allegedly my client lived. At some point, you're going to hear that another officer, Sergeant Rod Erdman, at about 10:20, after receiving a call about an alleged battery, went to the house of where my client was staying or living at on Flamingo and knocked on the door. There was no answer to the door. He left. You're going to hear evidence that Dale Kelly, the officer from Daytona Beach, was talking about just having a warrant issued, not doing anything further, but then alleged that he wanted to bring Ms. May to that location on Flamingo to bring the young lady to that location to get her personal things at, again, 805 South Flamingo, and that decided to go there as well. They went en route there. They left Ms. Mays down the block west of the location at a different intersection with the alleged belief that they're not going to bring her to Mr. Morrison's house in the event he's there. And if he is there and they arrest him, then they'll let her in to get her things. Again, the allegation was that she came along for the purposes of getting some of her personal items that, again, she supposedly said was there at that house. At some point, officers arrived again. Officers Armstrong and Kelly arrived at the South Flamingo location. They knocked on the door. We believe the evidence is going to be that they did not announce they were police, but they knocked on the door, the front door. Nobody showed up. They knocked on other side doors. Then at some point, Ms. Mays came up down the road, and she approached them.
Is there any dispute that the officers are uniformed at the time?
No, they're uniformed.
And they arrive in a marked patrol car?
That they parked down the block without lights and sirens. That's correct.
Okay, and I guess there were two.
There was two. Again, as we indicated to the court, there was Dale Kelly, who is the Daytona Beach police officer, and then there's Corporal Matt Armstrong, who's with the Holly Hill Police Department. They knocked on other locations there, tried to look into the garage to see if there was a motorcycle. They didn't see one. Ms. Mays showed up. There was a conversation that ensued. Thereafter, Ms. Mays was then placed through the chain link fence. I believe the evidence you're going to hear is that there was a lock on it. That lock was busted. Then after the chain link fence, there is a wood fence that totally secures the entire curtilage of the house all the way around.
I'm sorry, you said the lock was busted. Are you meaning that the police officers broke the lock off, or are you saying it wasn't working? And
No, we believe the police officers broke the lock off, although we don't have the evidence to say that we saw it or that it was videotaped, but that it was locked before Ms. Mays went through that chain link fence in order to get to the wooden fence. There's going to be evidence, we believe, that again, she went over the fence and was told, well, don't worry, if it's your place, you can do whatever you want. And these comments were constantly said to her. And she went over the wood fence and then opened it for the officers to gain entry into the curtilage after the chain link fence that they went through as well. That they were going back there to help her get her things. They traveled into the backyard. There were some dogs. The dogs were quieted. Ms. Mays then went to a location that is a totally enclosed area on the back of the house that has partially screened and partially wooden type doors, or panel doors that are partially screened, about 4 of them that slide to open up this back area of the curtilage, which is totally enclosed. It has, you'll see a washer dryer, it has a spa in it, it is totally enclosed, and at that point it was alleged that she attempted to get the attention of Mr. Morrison by yelling or saying she's there. Then at some point, we believe the evidence is going to be that she kicked out the window in the back of the house. You're going to hear some testimony that she was told that it's okay for her to kick out the back of the window, to kick it out, that since it's her place, she lives there, she can do whatever she wants. So she kicked out the back window. Officers, again, Officer Kelly, as well as Corporal Armstrong, was in the back of the location. Then we believe the evidence, again, is going to be questionable, but the state will try to present. We think that at some point after the window was kicked out, that Mr. Morrison allegedly had a weapon, a semi-automatic weapon of some type, and that pointed it from inside the house, did not break the curtilage or put it outside the window, but from within the house, a darkened, completely dark house at about 1:30 in the morning, allegedly put it in a view that they could see with only their flashlight, and at that point, they started having a conversation, and it's going to be alleged that my client used profanity during the entire time and made certain comments about who it was or what it was. I think the evidence is going to be that my client had contacted his daughter as well before this, not knowing who was breaking in, and called 911 to tell the police that somebody was breaking into his house, and not knowing who it was, and not necessarily believing who it may have been. At some point after this alleged gun was shown, we're going to have counter evidence, but then at that point the officers drew their weapons. Ms. Mays was able to get out of that curtilage back area, go to the front, get in the car, where she went to sleep in a police vehicle with her cats and some other items that she got off the back patio. Thereafter, they continued to talk to Mr. Morrison, and it was then alleged at some point that he walked by holding a gun down by his side, but didn't point it. And then there was a alleged second occasion that at some point he allegedly pointed it at them, upon which Corporal Matt Armstrong fired a round which shot Mr. Morrison through the back, leaving 2 holes in his back. And he then yelled out, of course, that he's been shot, and then he's going to the front door. I think the evidence is going to be clear that Mr. Morrison was standing near louver doors when the bullet rang out, shot him in the back, went through the louver doors into a container, a bag of sugar, which they recovered the bullet. The evidence is going to be, we believe, that the bullet, when it entered him into his back, left drops on the floor, but there's not going to be any photos of that. There'll be testimony of where he was standing, which is far back from the window. There'll be evidence that the gun was not anywhere near him in any form or fashion. We believe the evidence is going to be that he did not point the gun at these officers, but was shouting to them to leave, that they had no right to be there, that there was no search warrant, there was no arrest warrant, and that they were illegally on his property. We believe that once the court hears all the evidence, that the court will find that they were not in the lawful execution of their legal duty, whether it be to arrest for a battery, since they had already knocked and did not announce, and since others had been there and knocked, we believe that evidence is going to come into court in light of what went on. With everything that the court is going to receive in the form of evidence and exhibits and pictures, we're going to be asking the court to grant our motion to dismiss. We think that the crux of the issues is going to be whether or not the court finds that the officers were in the lawful execution of their legal duty.
Under 776.051?
Yes. And whether or not the statements made to them by Leah Mays, whether or not she had some interest in the house, whether she was living there or not, we don't think the officers would have been able to rely upon, since there was no documented proof that she lived there. We have evidence that she did not.
What's the standard on that? I mean, is it a reasonable basis? Is it beyond any doubt? I mean, what's the standard with regard to the officer's comment?
Well, Judge, I don't have case law directly on that point. I would consider it to be an objective that they need more proof than just some mere speculation of an allegation by somebody who says, I live there, and all of a sudden officers are allowed to break out windows or aid somebody in the commission of breaking out windows to put them into a house that they don't. So we think it should be, or is, an objective standard, not a subjective, that merely somebody says something, that's good enough. They knew where she lived.
So what's the objective standard?
The objective would be,
standard?
I would contend that if it isn't, it should be, and I don't know for sure because I don't have a case on that point precisely, but I would say that an officer should ask for a driver's license. And if it says that is the residence they live at, then clearly that would help them to be objective as to where they live. A voter's registration, a vehicle registration, a piece of mail or article of mail, or some other documented proof that the person lives or occupies a place at that residence. I think in our community that we live in the modern age, there's clearly a lot of proof that could be used to substantiate whether the person lives or not, instead of their mere comment that they have items there. Having items there,
It'd be more like a totality of circumstances type analysis.
I think so, Your Honor. And I would contend that they knew where she lived, and she lived in an apartment. That's where she lived. The documents we think that were given to the police demonstrate, as far as where to get in touch with her and various other things, shows that she lives at the 408 Ridgewood, South Ridgewood Avenue, apartment 206. There's numerous things that she did even during the course of this that demonstrate she was living at that apartment. Whether or not she had relations with somebody at many different locations does not mean she lived there. It just means she may have utilized it for a romantic involvement.
Am I going to hear from Ms. Mays today?
No, we don't know where she is. And we have been told, and I don't wish to make this worse, but that the police know where she is, but we can't find her. We've had private investigators looking for her. We've asked the state to reveal the whereabouts. We've advised the state that we think the police have worked with her and have a potential case against her and asked her not to show up. We can't find Ms. Mays. So,
If I can, we try to find it.
I'll let you get to that from your case.
Judge, as to the standard, we would cite in Illinois versus Rodriguez, the United States Supreme Court found that a battered live-in girlfriend could potentially be found to have that apparent authority to consent to the search of her boyfriend's residence if the facts available to the officer at the moment warrant a man of reasonable caution in the belief that the consenting party had authority over the premises.
So it's a reasonableness standard, right? Totality of circumstances, reasonable.
Yes, Your Honor.
Okay.
And do you want the cite on that, or do you want me to move on?
Sure.
Okay, according to Illinois versus Rodriguez, that's 497 U.S. 177 or 188 or 110 SCT 2793 or 111.
U.S. site's all I need.
Okay.
I can't look at it in the
Yes,
other
fine.
stuff. I get it all in the U.S. site.
No problem. It's going to be
Thank you.
in the case of United States versus Clay, which again was cited as 1 Florida Sub 3rd, 688, 2014. Mr. Cook will further comment upon all the cases and the case law that the court may have concern about.
Okay.
So we anticipate through the testimony of others that the court will find that, again, the officers were not in legal execution of their lawful duty when they aided and assisted Ms. Mays into gaining entry and ordering my client to come out of the house for no apparent reason, well beyond what they were entitled to do, and we're going to be asking the court to grant the motion to dismiss.
All right, thank you. All right, Mr. Cook, I assume that you'll summarize the case law and the law after we've heard the facts in the case?
That's correct, Judge.
Very good. Thank you very much. Mr. Reed?
Yes, sir. And just with the Leah Mays on the actually say, I mean, I don't know where she is either. I mean, if there's any, I don't know, statements that, you know, we're hiding her is ridiculous. We're not hiding her. I think we've tried to find her. I have no idea where she is either. And Judge, most of my argument I've laid out in this memorandum of law, which I guess you've been able to review. And also, before we get started, you know, Mr. Ross can correct me if I'm wrong, but we had agreed, this was written and filed as a motion to dismiss, a C4 motion. We've agreed to treat this as a summary judgment motion, which would be viewed in the light most favorable to the state. You know, can the state get past, have they present enough evidence for a prima facie case? So we've agreed to that, and just real quick, the reason we have agreed to that is I think you're going to see that the facts in this case are not terribly in dispute. I think for the most part, both sides are going to agree on what happened. The issue, in my mind, is what's the applicable law and how do you apply that law to it. And we talked about, Ms. Ross talked about lawful legal duty, and that's what the jury instruction says, as well as the statute for aggravated assault on a law enforcement officer. There's no definition of what the lawful legal duty is under the jury instructions, or as far as I'm aware, in any statute. So I think that the court is far more able to make that judgment than a jury would be. So that's one reason the state would agree to put this in Your Honor's hands rather than, you know, before we get to the jury. As far as the facts of the case, like I said, I think, you know, I'll put those on in a minute. I think most of it's not in dispute. You've heard it multiple times.
Let me ask, with regard to my job today,
Yes, sir.
with regard to a motion for summary judgment. I mean, typically, if there are factual issues, and I would think that performance of legal duty, a legal duty, potentially could involve factual issues. And by that I mean disputed factual issues. Is it the intention of the parties and the understanding of the parties that I'm going to make factual determinations to address these issues? Because in that respect, it wouldn't be a summary judgment.
Right. That's not, I mean,
If I could address that, and my understanding was this was not a C4 motion, which is in effect a summary judgment. We moved this to an evidentiary hearing as if it would be a motion for a judgment of acquittal standard,
Correct.
i.e. So it's not a summary judgment, what a C4 motion would be. As a necessity of that, you're going to have to make factual determinations here today.
Okay.
And I would,
Otherwise, if I did not, then obviously we couldn't address that ultimate issue. But that's an ultimate issue that Mr. Morrison, in the trial, is going to have a right to a jury trial on, all right? And so in that respect, am I not preempting what a jury would otherwise decide?
Well, the only thing I would say, Judge, is we treat it like the state had rested their case, and and you would say, in the facts most favorable to the state, did the state present a prima facie case?
Motion
So it's
for
not
judgment of acquittal.
right. So it's not like a bench trial. It's just like it's a judgment acquittal. That's exactly it.
Well, I'm going to make that determination based on the evidence that's presented here today.
Yes, sir.
Correct.
I just want to make sure that we're all clear on what I'm doing and the extent to which it interferes with Mr. Morrison's right of a jury trial.
Judge, there is no interference with his right to a jury trial, because ultimately, should the court, even though we anticipate the court will grant the motion, should the court deny it, he still has that right. So there's no implications to his right to a jury trial.
Okay. And I would agree. I didn't think of it that way, but I don't. He still have a trial if he wants.
It's not going to impact that one way or another.
Okay, well, you understand what I'm saying. I'm going to be making factual findings and determinations if this goes the way you both expect it
And
to.
we agree
I'm
to
in that position and you're agreeing to it.
That's
Yes,
correct.
sir. Yes, sir.
And bottom line is, if the court denies the motion, he still has all the rights associated with the jury trial. There's no prejudice there.
Right.
And the reason that, like I said, the reason the state's agreed to that is I think that this is a very unusual case, and there's factual determinations that Your Honor's better positioned to make than a jury would. As I've outlined in this motion, I think that the first issue that the court will need to look at is where the police acted in a lawful legal basis. So essentially, just as Mr. Ross said, the police are called to a domestic violence case in Daytona. They bring Miss Mays to Holly Hill. Miss Mays makes some representations to the police, which the police go through a chain link fence, a wooden fence, end up in a backyard, in a back porch, where Miss Mays breaks a window, they're exposed to the window. I mean, all that's, I agree, that happened. There's no search warrant, no arrest warrant. I agree. We've already put that on the record, but that's clear. That's when Mr. Morrison brandishes a gun, and that's when all this happened.
Is it your position that the police were going to the residence to effect an arrest of
Yes,
Mr.
sir.
Morrison?
Yes, sir.
Okay.
And that's what I think that...
Not just to put Ms. Mays in possession of her personal belongings?
Correct. No, the officers, I absolutely anticipate their testimony will be there to make an arrest.
Okay.
So that's when the gun's pointed, then there's a standoff, then there's another gun pointing, and there's a shooting. So first off, if the court finds the police were at a lawful legal basis right there, I think that the argument's done, then it gets past the JOA. If they don't, if the court doesn't, so essentially, if the court finds that if any evidence was collected, it'd be suppressed, if the police were not lawfully there, then I think you need to go further. And I think that I can see that analysis, and that's why I spent a lot of time researching this. And this is probably the longest motion I've filed. I honestly did it as best I could to find all applicable law, and I presented law that is against the state. And and that's my duty as the state, is to present both law. The reason I put such a history of this statute, the 776051, is I think it's applicable. Common law was, if the police were acting in a lawful legal basis, you could do whatever you wanted to resist it. That changed in the 70s when this 776051 was first enacted. There's a whole line of cases after this statute's enacted that says you just can't use force to resist an officer no matter what. You just can't, essentially, no matter what the officer's doing, you can't resist them. Those have been presented to the court. Then in 2006, I believe, Tillman comes out. Tillman says you have to read the narrow writing of the statute, and they even say the legislature messed this up, but we're going to say that we have to just read what the legislature does. And in that case, they overturned that entire line of cases, saying that if you're not in a lawful arrest, 776 doesn't apply. And they put that note, legislature might want to look at this and correct it. And they did. In 2008, the state legislature totally revamps that statute and says you can't resist arrest if the officer's in a lawful arrest, a lawful legal duty, or acting in a good faith basis. So that changes the standard now to good faith basis from lawful legal duty. Now I can see that's, I think the state legislature might still need to correct this, because now you have kind of a contradictory statute. But that's what they said they added this good faith basis. Again, this happened in 2012, so the first enactment's in 08. In 14, there's a change. And the reason I'm bringing this to the court's attention is because, again, I think it's my duty. I'm not trying to give you all the law. I've read the House bill. It's House Bill 89 that changes it. It's an NRA-sponsored bill where they add threat or, so in the quotes, or, I mean, it's you can't use force, and then quotes, or threat of force. So they add that line, or threat of force. The entire chapter 776 did not have or threat of force. And again, in candor to the court, the reason that's important is because there were courts that were not using, if threat of force was applied, they said then that statute does not apply. So what the NRA was upset about is if you were attacking me and I actually shot you, I could get a self-defense argument. If I fire a warning shot, I cannot get a self-defense argument because it's not threat.
So brandishing of a firearm is a threat,
obviously,
as opposed to a pointing and firing would be a use?
That's what some courts found. None of them that I could at least see were in regards to what we see here, but under again, I'm just trying to be honest with the court, under 776, that chapter, under the self-defense arm of the chapter, some courts did. I believe there's a big case out of Jacksonville where it was a mom had fired a warning shot and the court refused to give the jury instruction for self-defense because it was a warning shot, and they actually said if you had actually shot him, you could have got the self-defense argument. So that's why this NRA-sponsored House Bill 89 was enacted, and it's not enacted until 2014. Now, there were some courts that were equating threat of force and force. Some were not. So that's another question for the court is...
What does the 5th DCA say?
I didn't find anything on it.
Okay.
And when I read the House bill, it actually makes a lot of references, but it never cites any cases. And I've spent a lot of time on this issue and could not find anything that I thought was relevant. Everything I found, I gave to the court. So I didn't see anything from the 5th. Maybe I missed something, but I didn't find anything. So that's another question is, your first question is yes or no, were the officers acting in good faith? If no, then does 776.051 apply? And if it does the fact that this or threat of force wasn't in there, which, is admitted just as state legislature, I think just made a mistake, what does that have to do with it? Does that change anything? So that's why I'm saying there's all these legal issues that is the reason the state is wanting to present this to the court rather than to a jury. And I think that's kind of giving you a big outline of it. I think eventually, depending on how you rule, we'd also have to address what's the, if 776.051 does apply, well now the jury instructions I don't think are accurate, because we can't say, well, it's good faith basis when the jury instructions say you have to act in a lawful legal duty. We could address this stuff down the line, but those are the big issues I just wanted the court to be aware of.
So is it the state's argument that 776.051 applies or doesn't?
My argument is it does. I think that if it doesn't apply, it kind of kills my case. So,
okay.
But the reason I believe it applies, again, if you look at Tillman, killed the first iteration of it by saying you got to read the statute word for word as it is. My argument is clearly that's the legislature intended it to apply. Some courts applied, some courts didn't. That's the state legislature's intention. The House bill doesn't address whether or not it, didn't apply. They just say, and I've attached the House bill for you, but it just says we're clarifying it. So it doesn't say it's overriding it or not overriding it. It doesn't it's silent on it. So my argument is obviously that was the intention, and it should apply.
Well, I get the argument that if the statute applies, then the state's going to argue that the officers were engaged in the execution of a legal duty in good faith. And I get all of that.
Well, there's two. Well, I didn't mean to.
There's two of those standards, legal duty and in good faith. Okay, so we're actually in the language of the statute that the law enforcement officer was acting in good faith. So I assume that the testimony you're gonna give and the arguments you're gonna make are that you meet both of those elements under the statute.
Yes.
My question, the reason I asked it that way is, my question for you is, suppose the statute doesn't apply. Suppose the threatened use of force is not the use of force for purposes of the first part of the statute. So the statute doesn't apply. What's the state's argument?
Then it would have to meet, they were acting on a lawful legal basis. So it would be the original lawful legal standard. I mean, if you ruled, I mean, and I can see it, if you rule 776051 doesn't apply, so you take that out.
Right.
Now, we're back to, were the police officers in a lawful legal basis when they were on the back porch?
Right.
That's my only argument there. And it kills the rest of it.
We don't get into the good faith or any of that at that point.
If you ruled it's, well, yeah, because the only way good faith applies is if it's, 776 brings in good faith. Yes, sir.
Okay. Understood. All right. I
And just for
understand.
clarity's sake, Judge, we don't believe 776 applies. I think Mr. Ross said something to the contrary. We don't believe it does. And the reason we don't is it says a person charged with a criminal offense in which force was used, i.e. battery or murder. Now, that's not what Mr. Morrison is charged with. He's charged with an assault, an aggravated assault with a firearm, which is a threatened use of force.
Where are you looking?
We're looking at the summary analysis to the House bill.
I'm just looking at the statute. It doesn't say anything about that. It says a person is not justified in the use of force to resist an arrest by a law enforcement officer or to resist a law enforcement officer who is engaged in the execution of a legal duty.
Right. This is the summary analysis that when they amended in 2014 to add threatened use of force, they're
Right.
explaining why they indicated threatened use of force. So the bottom line is we're saying, number one, it doesn't apply because it wasn't at the time of arrest that the alleged ag assault occurred. And that's what that statute applies to, use of force at the time of arrest. Secondly, we believe that even if the court does find 776 applicable, the version at the time of the alleged offense in 2012 before the amendment in 2014 that add threatened use of force would not be applicable because it didn't add that language until after the alleged offense.
Let me ask this, if I do find the statute applies, and that your client's actions constituted a use of force to resist an arrest, that's as far as I need to go into the statute, right? I don't even have to get into whether or not the officers are engaged in the execution of a legal duty or are acting in good faith, right?
No, you do, Judge, and here's why. Because there's different iterations.
Isn't
right?
there an or here? Resist an arrest or resist a law enforcement officer who is engaged in the execution of a legal duty. So the assumption under the statute is if you're perfecting an arrest, you're engaged in a legal duty, right?
I guess under the statute there would be, but we're saying that's not what happened here. They weren't effecting an arrest.
Well, I don't know. Well, we have to hear the facts, and that's why I was asking you to address the legal issues after we've heard the facts. But I'm just trying to get the syllogism, if you will, the sequence under the statute, and it would be in that fashion, right?
Well, I guess the iteration at the play would be either they were acting in the lawful execution of a legal duty, number one, or alternatively they were acting in good faith. Those were the ones that were applicable in 2012 if the court finds 776 applies. However, again, the argument is the iteration in play at the time of the offense did not encompass the threatened use of force, and that's an element of the offense that Mr. Morrison is charged with. Ergo, the threatened use of force would be applicable, and therefore, at the time of 2012, that law is inapplicable.
Right, so it'd be carrying or pointing a gun as threatened use as opposed to the actual use.
That's correct, and that's an element of the offense that he was charged with. He's not charged with resisting with violence. He's not charged with battery on a law enforcement officer.
Okay, thank you, Mr. Cook. All right, Mr. Ross, you ready to?
First and foremost, before I begin, I'd like the court to take compulsory judicial notice of the court file. If the court has a file anymore, now that we have computers.
I do,
Okay.
and I have.
And if, does the court agree to do that?
Yes.
Okay,
Yeah, I don't think I have any choice, by the way.
because then there should be in the court file, which I'm going to have marked in a minute. Judge, the state is looking at a document that I'm going to ask the court to find in the court file, which is part of the court file. It's from Leah Mays. It's a handwritten document. It's
Why don't
a,
you give me a head start, I'll see if I can find it.
thank you, Judge. It's a 3-page document, I
What's the
believe.
date of it?
It's handwritten. The date of it is 10/23/13.
And can you tell me what date it was filed in court
Judge, when I
correspondence?
show the report, it looks like it's stamped and filed as.
Does it say to whom I may concern? To whom I may concern, I am writing to ask for a
Yes.
no contact order be
Yes.
removed. Okay, it's in the court file and it's document number, looks like 142. Yeah, that's what I'm looking at. 164, filed October 23rd, 2013. Just so you know, I did not read this.
Well, Judge, I'd like to read it. The report will only take me about probably 5 minutes for the record.
Let me spare you that, I'll read it. It's clear, I can read it myself.
Thank you,
Just a
Judge.
minute.
Thank you.
Certainly, I'm going to give you every opportunity to emphasize what you want to emphasize by way of argument. but
Yes, Your Honor.
You don't have to read it.
Yes, Your Honor. Thank you.
And just, when I'm reading, I just object to the record that you taking that into any evidence. I think it's hearsay and it's certainly not properly authenticated. So that'd be my objection.
Okay, your response?
Judge, it goes to show present state of mind as well, but also answers a few of the other exceptions to the hearsay rule. And Judge, we believe that it should come in, especially in an evidentiary hearing, in order to, I can go through the list of the exceptions if the court wants me to.
I do. I think we all agree it's hearsay. The question is there an exception to the hearsay rule that would allow the court to receive it into evidence? It's in the court file, there's no doubt.
And I often do that. I mean, I don't think it's properly authenticated. I don't think I get this file stuff in the court file
Mr. Bross is asking the court to consider it as evidence by asking the court to take judicial notice. So he wants to basically admit it into evidence and have the court consider the truth of the matters asserted in that correspondence. Mr. Bross isn't contending it's not hearsay. He's contending that it may fall under an exception to the hearsay statute. So,
I just wanted to make sure my objection that that's not properly authenticated to just say you're taking judicial notice of the court file. Because then I could file any document I want with the court and then say, can you take judicial notice, and that authenticates it. That's obviously not, you'd have to have somebody, we don't even know she wrote it.
no, I understand. I understand by being in the court file, it doesn't put it in evidence. Mr. Bross understands that. All he's saying is that it may fall under an exception. He's looking at that. Mr. Bross, your argument in that regard?
Thank you, Judge. As to the exception, I would say under 90.803, then existing mental, emotional, or physical condition, a statement of the declarant's then existing state of mind, emotion, or physical sensation, including a statement.
What's the date of this?
The date of the document?
Yeah.
Well, other than I know that it's dated 10/23/13, as the copy was given to Judge Frank Marriott, and it's filed on October 13th.
23rd of 13.
Right.
Okay. So it's not a contemporaneous statement. I mean, it's a year old, I guess.
You may very well be, Judge.
Okay. What else? You got any other exceptions?
It's offered to prove or explain acts of subsequent conduct of the declarant. It's a memorandum, a recorded recollection, a memorandum or record concerning a matter about which the witness once had knowledge, but now may have insufficient recollection because she's truly unavailable. We can't find her. State can't produce her. We can't find her. She's a victim in this case. We believe it acknowledges a memorandum or record. The party may read into evidence a memorandum or record when it is admitted that no such memorandum or record is admissible as an exhibit unless offered by an adverse party. We think we're adverse to the allegation that she's a victim in the case and that somehow she was injured, battered, or she gave permission or consent to enter into a dwelling that she had no consent or no ability to give or grant consent to enter into. She wasn't living there. That strictly indicates that she was not living there at that residence in Flamingo. Hold on a second. It could be under 15 statements and documents affecting an interest in property. A statement contained in the document purporting to establish or affect an interest in property if the matter stated was relevant to the purpose of the document, unless dealing with the property since the document was made, have been inconsistent with the truth of the statement or the purport of the document. We contend it's a document that indicates that she does not have any interest in the property at Flamingo. The location, again, as we indicated to the court, where allegedly my client lived. So it's a document that purports to, again, indicate that she has no interest, she was not living at 805 South Flamingo at or about the time of the events as stated in the document, which is under number 15 of the exception. May also fall under number 18 as an admission, the statement that is offered against the party and is.
Is she a party?
Well, we believe she's a party for the state. She's a victim that the state would have utilized if given the opportunity to find her and bring her here, or they've chosen not to. We believe, therefore, she is a party. She is not a defendant, absolutely not. But we think that other individuals on behalf of the state are parties to this action. However, the court defines a party, and of course, that's why the court's sitting up there and I'm down here, Judge.
Okay.
So I would argue that it's an admission of the party's own statement in either an individual or representative capacity, a statement of which the party has manifested adoption or belief in its truth, a statement by a person specifically authorized by the party to make a statement concerning the subject, a statement by a person who was a co-conspirator of a party during the course and furtherance of the conspiracy. That doesn't apply in this case.